election took place in East Pakistan. Mujibur Rahman won. There was it was unleashing of violence. He was not allowed to be sworn in. That's what happened.
70.
Yes, in 70, December 70. That's the violence that happened. He was not allowed to be sworn in.
But that is 3 months before our cutoff.
That's why, Malad, that's precisely why I'm saying, Malad, that 3 months has been also excluded, as your Lordship sees now, from March onwards. Therefore, Malad, it has nothing to do. This exodus didn't happen from East Pakistan or Bangladesh at that point in time. This is all prior.
I mean, there's one way of dealing with it, which is that Parliament has legislative domain over what cutoff date to adopt.
That, of course.
Unless the cutoff date is palpably arbitrary.
That's correct. That's correct.
You normally allow Parliament.
But apart from that,
I mean, that can always be a judicial mantra, but we are trying to figure out what was the logic.
But Malaj, it's not just a cutoff date. It is to prove, if you prove your residence.
Sorry?
It's not, said Malaj, a person who got 17% of the 2% vote, Malaj won the election. So that was rejected by the people. So it was, but Malaj, the 66 onwards, you had to show evidence that you were resident for 10 years. And therefore there are only two aspects, the date and the territory. The tea plantations, the traders came much earlier. So the date and the territory are the two aspects, Malaj, which are considered by deeply obliged.
Thank you, Mr. Sibal. Yes, Ms. Jaisingh.
Yes,
No, my lord is only confining to 6A. Why are you worried? They were worried they'll go beyond 6A. Of course not. We haven't argued that.
No, we are very clear in our mind. We have not heard
Because
Mr. Diwan has not argued that. Mr. Solicitor has not argued anything beyond 6A.
Because 2024 is round the corner, Malad, then nothing should be there.
I don't think that is.
No, I'm saying
2024 has no relationship with the constitutional main.
No, I'm saying nothing should be said.
But Mr. Sibal, equally, we must make it clear. You probably all have, you've got the drift of it, irrespective of what happens to 6A, and our minds are open until the last word is said by Mr. Diwan and the others. Irrespective of that, we intend, because it's a constitutional court, on what is being done to take care of the problem of illegal migration. That's something which I think we have to address in this judgment. And we do propose to address it because irrespective of what happens to their plea on 6A, I mean, the cause of the petition, there is a great deal of there's a great deal of substance in what their grievance. I mean, look, what are you doing to our state?
But therefore, I will not very categorically and candidly say that I am not trivializing their problem.
No, neither are we.
I am answering only the constitutional question. This is a serious question, and as a custodian of fundamental rights of all citizens, the Lordship
we have to address that in any case.
We must, all of us must. No doubt about it.
Yes, Ms. Yes, Ms. Jaisingh.
May please, my lords. My lord, I would like to take off from where Mr. Sibal left off. I think the question of plenary powers has been adequately addressed. I will not address that, except to say.
Mr. Sibal and Ms. Jaisingh to just indicate who they are appearing for.
Yes,
that we
I want
Yes,
to
Mr.
precisely that.
I didn't ask you your writ petition.
Yes, my lord, I'll give you my writ petition.
My notes, Malaj, who I'm appearing for.
It's now called in re 6A.
Apropos what fell from Ms. Jaisingh a moment ago, as we have done in the case of the marriage equality, Article
Yes.
370, can we call the judgment in re 6A of
My
the
lord,
Citizenship
I would
Act?
agree with
Yes,
that,
yes.
respectfully agree.
Mr. Diwan, I think
Yes,
that's already there. That's already there.
yes, it's already showing on the board as in re 6A. It's showing on the board as in re 6A.
So what is the
But my lord, since the question has been asked who I'm appearing for, and the latter, my lord, is the one in which the reference has been made. Now, my lord, as I said, let me begin with where Mr. Sibal has left off. My lord, it has been said by academics the world over that the 21st century is the century of refugees and migrants. And if you shifted one century back, then the 19th century also was a century of refugees and migrants insofar as India is concerned. My first submission is that the Constitution of India bears the birthmarks of partition. And you cannot understand either the Constitution of India or the Citizenship Act without understanding what happened for almost a century before the partition occurred. And what led up to this partition. And the birthmarks are there in the Constitution. Article 5 confines itself to the commencement, as has already been said. 6 and 7 deal with migration to and from Pakistan. And the Citizenship Act deals with acquisition of citizenship after the Constitution comes into force. My submission is going to be Section 6A is a sui generis provision. And that's why it's called special provision. So it cannot be slotted either into the Constitution or into Section 4 and 5. Possibly it can be slotted into Section 7 of Article 7, a proviso. Because my submission is the proviso to Article 7 leaves the door open for further migration and does not freeze the cutoff date at 19th March 1947. 1948. There's no freeze to migration, or there's no freeze to granting citizenship to people who enter India after 17th March 1948. And that is obvious from a reading of the proviso to Article 7. I'll make good that submission. Then, my lord, I'll address a few issues on Article 29, because 14 has been adequately addressed, 11 has been adequately addressed. I will not cover the same ground. My lord, in my opinion, 29 has not been adequately addressed, and I'll attempt to do so. In fact, the Attorney General did not address 29 at all. I'm sorry, the Solicitor General made no submissions on Article 29. And my lord, from what I understood by the opening arguments of Mr. Diwan, his major focus was on 29. And that major focus was confined to demographic changes. Nothing more, nothing less. It was not his case that the script, the language, or the culture of Assam has been impacted. If it was, I have not understood in what manner. And may I explain, my lord, I would like to invite your attention to certain provisions of the Constitution of India. Assamese continues to be in the schedule of official languages of India. Point number 1.
1 second.
Under the Constitution, adequately, completely protected. No question, my lord, of destruction of the language. Number 2, Assamese continues to be the official language of the state of Assam. Remember, my lord, at one time, Mr. Sibal informed you that Bengali was forcibly made the language of Assam. That was reversed. And Assamese continues to be the official language of the state of Assam. Therefore, my lord, there's complete protection of language script.
Bengali is also the official
Yes.
language of the state.
Yes.
And Bodo is also an official language.
Yes, my lord, I'm grateful for that information.
Assamese is the only.
My lord, I'm very grateful for that information, because we are talking about a state which is bilingual. And therefore, my lord, what is the point of producing data to show the number of Assamese speaking people as against the number of Bengali speaking people in the state of Assam? It makes no sense. It's a bilingual state, a multilingual state. And as Mr. Sibal submitted, my lord, it is one of the most diverse states in the country because of the mass migrations that have taken place over the centuries, my lord, long before the Ahoms came to India, long before that. There has been migration into Assam. And this has led to the creation of a syncretic culture. No submissions were advanced on how the culture of Assam has been impacted. Now, my lord, a few more provisions of the Constitution of India need to be pointed out to see the special protection given to the state of Assam. First of all, under Article 342, the President of the Parliament passes laws naming scheduled castes and scheduled tribes in different states. And my lord, I will share it with you because it's in the public domain. There is a law of Parliament in 1976, which gives you the names of the tribes who have been put in the presidential schedule the intention being to protect their culture. These are constitutional provisions for protection of culture, which are in place. Then, my lord, your lordship will turn to Article 244 of the Constitution of India. I'm going through the list of constitutional provisions which are intended to protect the state of Assam and in particular the tribals. My learned friend Mr. Divan said each of his petitioners represent a certain tribe. And I presume it was his case that it was tribal culture which is being destroyed. Now, my lord, we turn to 244 of the Constitution. Yes. Administration of scheduled areas and tribal areas. The provisions of the 5th schedule shall apply to the administration and control of scheduled areas and scheduled tribes in any state other than the states of Assam, Meghalaya, Tripura, and Mizoram. Special provisions have been made for these states given their history. Now, my lord, the provisions of the 6th schedule shall apply to the administration of the tribal areas of the states of Assam, Meghalaya, Tripura, and Mizoram. Then come to Article 244A. Formation of autonomous states comprising certain tribal areas in Assam and creation of local legislative and council of ministers of both thereof. There again, my lord, there's a special dispensation for self-governance of tribal areas. One of the submissions made was self-governance is covered by Article 21. No attempt was made to justify that submission, but I'm giving you the answer. If self-governance is a right, yes, it is protected insofar as Assam is concerned in relation to tribals under Article 244A. Tribal areas have been put in a separate schedule which gives them autonomy of administration. Now, my lord, these are the provisions which conserve customs.